The dispositions in the following cases: 74-62-57, Gregg against Georgia; 75-57-06, Proffitt against Florida; 75-53-94, Jurek against Texas; and 75-54-91, Woodson against North Carolina; 75-58-44 will be announced by Mr. Justice Stewart, Mr. Justice Powell, Mr. Justice Stevens. Mr. Justice Stewart.
In the first of these cases, Troy Leon Gregg, petitioner against the state of Georgia. There is no opinion for the court. However, Mr. Justice Powell, Mr. Justice Stevens, and I have filed a joint opinion with the clerk this morning, which, because of the divisions among the court, is the prevailing opinion. In summarizing our opinion in this case, I speak as much for Mr. Justice Powell and Mr. Justice Stevens as I do for myself. This, as I say, is a joint opinion. The issue in this case is whether the imposition of the sentence of death for the crime of murder under the law of Georgia violates the 8th and 14th Amendments. The petitioner, Troy Gregg, was charged with committing armed robbery and murder. In accordance with Georgia procedure in capital cases, the trial was in 2 stages, a guilt stage and a sentencing stage. The evidence for the prosecution at the guilt stage established that on November 21st, 1973, the petitioner murdered and robbed 2 men in Gwinnett County, Georgia, and the jury at the end of the trial found the petitioner guilty on 2 counts of armed robbery and murder. At the penalty stage, which took place before the same jury, the trial judge instructed the jury that it could recommend either a death sentence or a sentence of life imprisonment on each count. The judge further charged the jury that in determining what sentence was appropriate, the jury was free to consider the facts and circumstances presented by the parties, if any, in mitigation or aggravation. Finally, the judge instructed the jury that it would not be authorized to consider imposing the sentence of death unless it first found, beyond a reasonable doubt, one of 3 relevant statutory aggravating circumstances. Finding 2 of these circumstances, the jury returned verdicts of death on each count. We consider at the outset the basic contention that the punishment of death for the crime of murder is, under all circumstances, cruel and unusual in violation of the Constitution. For the reasons that Mr. Justice Powell will summarize thoroughly in announcing our opinion in the case of Proffitt against Florida, we reject that contention. We therefore must consider the specific constitutionality of Georgia's capital sentencing procedures. In the wake of this court's judgment in the Furman case 4 years ago, Georgia narrowed the class of murderers subject to capital punishment by specifying 10 statutory aggravating circumstances, at least one of which must be found by the jury to exist beyond a reasonable doubt before a death sentence can ever be imposed. In addition, the jury is authorized to consider any other appropriate aggravating or mitigating circumstances. The jury is not required to find any mitigating circumstance in order to make a recommendation of mercy that is binding on the trial court, but it must find a statutory aggravating circumstance before recommending a sentence of death. These procedures require the jury to consider the circumstances of the crime and of the criminal before it recommends sentence. No longer can a Georgia jury do as Furman's jury did, reach a finding of the defendant's guilt, and then, without guidance or direction, decide whether he should live or die. Instead, the jury's attention is directed to the specific circumstances of the crime. Was it committed in the course of another capital felony? Was it committed for money? Was it committed upon a peace officer or judicial officer? Was it committed in a particularly heinous way or in a manner that endangered the lives of many persons? In addition, the jury's attention is focused on the characteristics of the person who committed the crime. Does he have a record of prior convictions for capital offenses? Are there any special facts about this defendant that mitigate against imposing capital punishment, such as his youth or his emotional state at the time of the commission of the crime? As a result, while some jury discretion still exists, the discretion to be exercised is controlled by clear and objective standards so as to produce, insofar as possible, non-discriminatory application. As an important additional safeguard against arbitrariness and caprice, the Georgia statutory scheme provides for automatic appeal of all death sentences to the state's Supreme Court. That court is required by statute to review each sentence of death and to determine whether it was imposed under the influence of passion or prejudice, whether the evidence supports the jury's finding of a statutory aggravating circumstance, and whether the sentence is disproportionate compared to those sentences imposed in similar cases. In short, Georgia's new sentencing procedures require, as a prerequisite to the imposition of the death penalty, specific jury findings as to the circumstances of the crime and the character of the criminal. Moreover, to guard further against a situation comparable to that presented in the Furman case, the Supreme Court of Georgia compares each death sentence with the sentences imposed on similarly situated defendants to ensure that the sentence of death in a particular case is not disproportionate. The basic concern of the Furman decision centered on those defendants who were being condemned to death capriciously and arbitrarily. Under the procedures before the court in that case, juries were not directed to give attention to the nature or circumstances of the crime committed or to the character or record of the defendant. Left unguided, juries imposed the death sentence in a way that could only be called freakish. The new Georgia sentencing procedures, by contrast, focus the jury's attention on the particularized nature of the crime and the particularized characteristics of the individual defendant. While the jury is permitted to consider any aggravating or mitigating circumstances, it must find and must identify at least one statutory aggravating factor before it may impose a penalty of death. In this way, the jury's discretion is channeled. No longer, therefore, can a jury wantonly and freakishly impose the death sentence. It is always circumscribed by the legislative guidelines. In addition, the review function of the Supreme Court of Georgia affords additional assurance that the constitutional concerns that prompted our decision in Furman are not present in the Georgia procedure applied in this case. For the reasons I have summarized, which are set out at considerable length in the written opinion that Mr. Justice Powell, Mr. Justice Stevens, and I have filed today, we hold that the statutory system under which Gregg was sentenced to death does not violate the Constitution. Accordingly, the judgment of the Georgia Supreme Court is affirmed. Mr. Justice Brennan has filed a dissenting opinion. Mr. Justice Marshall has also filed a dissenting opinion, which he will shortly announce orally.
the reasons stated in an opinion I have filed for myself, the Chief Justice, and Mr. Justice Rehnquist, I concur in the judgment and agree that the sentence in this case should be sustained. Chief Justice, Mr. Justice Rehnquist, and I agree with the plurality that the death penalty is not a cruel and unusual punishment under any and all circumstances. It was not thought to be at the time the Eighth Amendment was adopted, and the recent decisions of 35 state legislatures to authorize imposition of the death penalty under various narrowly defined circumstances refute any argument that the death penalty has become cruel and unusual as our society's standards of decency have evolved since the Eighth Amendment's adoption. Reasonable men and reasonable legislatures may differ on the question whether the death penalty serves to deter murders or serves any other valid penological interest. But so long as the penalty is imposed with some reasonable consistency with respect to a given category of murder, resolution of this question, at least on the present evidence, is simply not for this court, but for the states and for Congress, who are quite free to reject capital punishment if they see fit. Petitioner's other major argument in this case is that the issue of sentencing under the Georgia scheme is controlled by such vague and indeterminate standards that the death penalty will inexorably be imposed in as discriminatory, standardless, and rare a manner as it was imposed under the scheme that was declared invalid in Furman. Like the plurality, we do not agree. The Georgia legislature has made an effort to identify those aggravating factors which it considers necessary and relevant to the question whether a defendant convicted of capital murder should be sentenced to death. It has plainly made an effort to guide the jury in the exercise of the discretion vested in it, and we cannot accept the naked assertion that the effort is bound to fail because the jury will so often and systematically refuse to follow the guidelines laid down for it. As the types of murders for which the death penalty may be imposed become more narrowly defined and are limited to those which are particularly appropriate, as they are in Georgia, by reason of the aggravating circumstances requirement, it becomes reasonable to expect that juries, even given the discretion not to impose the death penalty, will impose it in a substantial portion of the cases so defined. If they do, it can no longer be said that the penalty is being imposed wantonly, freakishly, or so infrequently that it loses its usefulness as a sentencing device. There is, therefore, reason to expect that Georgia's current system will escape the infirmities which were found to invalidate its previous system under Furman. In addition to jury guidance, the legislature has also assigned to the Georgia Supreme Court the important role of ensuring that capital punishment will not be imposed in a discriminatory or standardless fashion. There is discretion in the Georgia system, to be sure, but at this juncture we cannot conclude that it threatens to invalidate the statute. In reaching this result, however, the Chief Justice, Mr. Justice Rehnquist, and I, and as I understand Mr. Justice Blackmun, who also concurs in the judgment, he is in like posture, do not find it necessary, in effect, to overrule McGautha v. California, decided only a few terms ago, and to demand as a constitutional requirement that capital punishment be imposed only after a separate sentencing proceeding, conducted and structured as our brothers Stewart, Powell, and Stevens would have it. For us, at least where first-degree murder is involved, it is enough to be consistent with Furman and with the 8th and 14th Amendments that the state required the death penalty be imposed with reasonable consistency for a given category of crime. This the Georgia statute does, and we affirm the judgment of the Georgia Supreme Court. As I have indicated, Mr. Justice Blackmun also concurs in the judgment, but for the reasons stated in dissent in Furman v. Georgia.
In Furman against Georgia, I concluded that the death penalty is a cruel and unusual punishment prohibited by the 8th and 14th Amendments, and that continues to be my view. In Furman, I concluded that the death penalty is unconstitutional for two reasons. First, the death penalty is excessive. And second, the American people fully informed as to the purpose of the death penalty and its liabilities, but in my view reject it as morally unacceptable. Since the decision in Furman, the legislatures of 35 states have indeed enacted new statutes authorizing the imposition of the death sentence for certain crimes, and Congress has enacted a law providing the death penalty for the piracy resulting in death. I would be less than candid if I did not acknowledge that these developments have a significant bearing on a realistic assessment of the moral acceptability of the death penalty to the American people. But if the constitutionality of the death penalty turns, as I have urged, on the opinion of an informed citizenry, then even the enactment of new death statutes cannot in of themselves be viewed as conclusive. In Furman, I observed that the American people are largely unaware of the information critical to a judgment on the morality of the death penalty, and there concluded that if they were better informed, they would consider it shocking, unjust, and unacceptable. A recent study has confirmed that the American people know little about the death penalty, and that the opinions of an informed public would differ significantly from those of a public unaware of the consequences and effects of the death penalty. Even assuming, however, that the post-Furman enactments of statutes authorizing the death penalty renders the prediction of the views of an informed citizenry an uncertain basis for a constitutional decision, the enactment of these statutes has no bearing whatsoever on the conclusion that the death penalty is unconstitutional because it is excessive. An excessive penalty is valid under the cruel and unusual punishment clause, even though popular sentiment may favor it. The inquiry here, then, is simply whether the death penalty is necessary to accomplish the legitimate legislative purposes in punishment, or whether a less severe penalty, such as life imprisonment, would do just as well. The two purposes that sustain the death penalty as non-excessive in the court's view are general deterrence and retribution. In Furman, I canvassed the relevant data on the deterrent effect of capital punishment. The state of knowledge at that point, after literally centuries of debate, was summarized in the United Nations Committee, which committee said it is generally agreed between the retentionists and the abolitionists, whatever their opinion about the validity of comparative studies of deterrence, that the data which now exists shows no correlation between the existence of capital punishment and lower rates of capital crime. I concluded in Furman, and I conclude today, that the available evidence is simply convincing that capital punishment is not necessary as a deterrent to a crime in our society. The other principal purpose said to be served by the death penalty is retribution. The notion that retribution can serve as a moral justification for the sanction of death finds credence in the opinion of my brothers Stewart, Powell, and Stevens, and that of my brother White. It is this notion that I find to be the most disturbing aspect of today's unfortunate decision. My brother Stewart, Powell, and Stevens, after the following explanation of the retributive justification for capital punishment, have this to say. The instinct for retribution is part of the nature of man, and challenging that instinct in the administration of criminal justice serves an important purpose in promoting the stability of a society governed by law. When people begin to believe that organized society is unwilling or unable to impose upon criminal offenders the punishment they deserve, then there are sown the seeds of anarchy or self-help, vigilant justice, and lynch law, end of quote. This statement is wholly inadequate to justify the death penalty. As my brother Brennan stated in Furman, there is no evidence whatsoever that utilization of imprisonment rather than death encourages private blood feuds and other disorders. It simply defies belief to suggest that the death penalty is necessary to prevent the American people from taking the law into their own hands. In a related vein, it may be suggested that the expression of moral outrage through the imposition of the death penalty serves to reinforce basic moral values. That it announces in the strongest possible way that murder is wrong and therefore to be avoided. Well, this contention, like the previous one, provides no support for the death penalty. It is inconceivable that any individual concerned about conforming his conduct to what society says is right would fail to realize that murder is wrong if the death penalty was simply real, true life imprisonment. There remains for consideration what might be termed the purely retributive justification for the death penalty. That the death penalty is appropriate, not because of its beneficial effect on society, but because the taking of a murderer's life is itself morally good, end of quote. Some of the language of the plurality opinion appears positively to embrace the notion of retribution for its own and as a justification for capital punishment. In the opinion of plurality, it said that decisions that capital punishment may be the appropriate sanction in extreme cases in the expression of the community's belief that certain crimes are themselves so grievous and affront to humanity that the only adequate response may be the penalty of death, end of quote. In other words, as I understand the argument, society's judgment that murder deserves death must be respected not simply because the preservation of order requires it, but because it is appropriate that society make the judgment and carry it out. It is this latter notion in particular that I consider to be fundamentally at odds with the Eighth Amendment. The mere fact that the community demands the murderer's life in return for the evil he has done cannot sustain the death penalty. For as the plurality reminds us, quote, the Eighth Amendment demands more than a challenged punishment be acceptable to contemporary society, end of quote. To be sustained under the Eighth Amendment, the death penalty must be comport with the basic concept of human dignity at the core of the amendment. The objection in opposition to it must be consistent with our respect for the dignity of other men. Under these standards, the taking of life because the wrongdoer deserves it surely must fall for such a punishment as, at its very basis, the total denial of the wrongdoer's dignity and worth. The death penalty, unnecessary to promote the goal of deterrence or to further any legitimate notion of retribution, is an excessive penalty forbidden by the 8th and 14th Amendments, and I therefore respectfully dissent.
I have the judgment to announce in 75-5706, Proffitt against the state of Florida. This case is here on certiorari to the Supreme Court of Florida. It presents the challenge to the capital punishment statute of that state. As the justices who have preceded me have stated, the threshold question, the fundamental one presented in all 5 of the cases here today, is as follows. Whether the punishment of death for the crime of murder is, under all circumstances, cruel and unusual in violation of the 8th and 14th Amendment of the Constitution. If we had answered this question in the affirmative, it would be unnecessary to consider the statutes and the procedures in these 5 states. As has been indicated, 7 members of the court have concluded that capital punishment is not unconstitutional per se. Mr. Justice White, speaking for the Chief Justice, and Mr. Justice Rehnquist, has summarized their reasons for agreeing with this conclusion. I now speak for Justices Stewart, Stevens, and myself. In our joint opinion in Gregg v. Georgia, we elaborate on our reasons for reaching the same conclusion. We incorporate these reasons by reference in the joint opinions filed by the 3 of us in each of the other 4 cases. The precedents of this court, extending over many years, establish the guiding principles. The 8th Amendment is not a static concept. It draws its meaning from the evolving standards of decency that mark the progress of a maturing society. A penalty must not involve unnecessary and wanton infliction of pain, nor can it be substantially out of proportion to the severity of the crime. As long as the penalty specified by the legislature comports with these criteria, we must defer to the judgment of the elected representatives of the people on this basic issue. No one can doubt that the death penalty was contemplated when the Constitution was adopted. It was a traditional penalty both in the colonies and in England. The text of the Fifth Amendment, reiterated in part in the 14th Amendment 75 years later, makes clear the acceptance of capital punishment. And in the nearly 2 centuries of our national existence, until 1972, this court repeatedly and often expressly recognized that capital punishment is not invalid per se. In Trope against Dulles, decided in 1958, then Chief Justice Warren, in the same opinion in which he spoke of evolving standards of decency, said this: the death penalty has been employed throughout our history, and in a day when it is still widely accepted, it cannot be said to violate the constitutional concept of cruelty. The first major challenge to the per se validity of capital punishment reached this court in 1972 in Furman. Although the issue was strongly presented in that case, it was not then resolved by the court. 4 justices would have held that capital punishment is not invalid per se. 2 would have reached the opposite conclusion, and 3 justices, while agreeing that the statutes then before the court were invalid as applied, left open the question whether such punishment may ever be imposed. The principal argument presented by petitioners in Furman was that standards of decency had evolved to the point where capital punishment was no longer tolerated in this country. It was said then that the Eighth Amendment must be construed finally as prohibiting capital punishment for any crime, regardless of its depravity and of its impact on society. Petitioners in the 5 cases here today have renewed the standard of decency argument, but as Mr. Justice White has noted, developments during the 4 years since Furman have undercut substantially the assumptions upon which that argument was advanced. Objective criteria demonstrate that prevailing standards in our country do not reject capital punishment, at least as a sanction in some cases. The most marked indication of society's endorsement of the death penalty for murder is the legislative response to Furman. The legislatures of at least 35 states and the Congress of the United States have enacted new statutes that provide for this penalty, at least for some murders. The jury also is a reliable, objective index of contemporary values. It has a fearful responsibility and is directly involved. And yet, since Furman and under the new statutes, juries across the country have imposed the death penalty in more than 400 cases. But the Eighth Amendment demands more than a finding that a challenge punishment is acceptable to contemporary society. As noted above, a penalty may not be substantially out of proportion to the severity of the crime, nor may it be totally without penological justification. We cannot say that the infliction of death as a punishment for murder is without justification. In part, capital punishment is an expression of society's belief that certain crimes are so grievous an affront to humanity, that the only adequate response is the penalty of death. In part, capital punishment also reflects a legislative judgment that the sanction is necessary to deter capital crimes. There is no conclusive empiric data, either proving or disproving the value of the penalty as a deterrent. Yet we may assume, we do assume, that there are murders, such as those committed in the heat of passion, for which the threat of death has little or no deterrent effect. But there are others, for example, those that are deliberately planned in advance, where the penalty may well be a deterring factor. And in some cases, such as murder by a life prisoner, there is no other adequate sanction. The evaluation of the unresolved debate concerning deterrence properly rests, as Mr. Justice White has said, with the legislatures. They have the flexibility and the means to ascertain the facts that are quite unavailable to the judiciary. It is well to remember that we are concerned in these cases only with the imposition of capital punishment for the crime of murder. We conclude, when a life has been taken deliberately, that the punishment of death is not invariably disproportionate to that crime. It is an extreme sanction, but it is suitable for the most extreme of crimes. I come now briefly to the Florida case itself. I will not state the facts beyond saying that petitioner, in the course of an unlawful entry into a private home at 3 a.m. in the morning, stabbed to death his sleeping victim and beat the victim's wife. The Florida statute, in all material respects, provides the same procedural and substantive safeguards as the Georgia statute described by Mr. Justice Stewart. Florida provides for a bifurcated procedure. In this case, after the jury had found petitioner guilty, a separate hearing was held to determine whether the sentence should be death or life imprisonment. The Florida statute requires consideration of specified aggravating and mitigating circumstances. Acting in light of these, the jury recommended the sentence of death. The trial judge then imposed that sentence and identified in writing 4 of the statutory aggravating circumstances. Again, as in Georgia, automatic review by the Florida Supreme Court is required by statute. That court reviews and evaluates the sentence in comparison with and to assure consistency with similar cases. For reasons more fully stated in our opinion filed today, we conclude that these safeguards provide the procedural protection that prevent the wanton and freakish imposition of capital punishment that was held unconstitutional in Furman against Georgia. Accordingly, Mr. Justice Stewart, Justice Stevens, and I would affirm the judgment of the Supreme Court of Florida. As the Chief Justice and 3 other justices concur in the result, this is the judgment of the court. Mr. Justice Brennan and Mr. Justice Marshall have filed dissenting opinions.
I have filed an opinion in this case, concurring in the judgment, and the Chief Justice and Mr. Justice Rehnquist have joined the opinion I have filed. There is no need to repeat the facts of the case or to restate the statutory procedure under which the death penalty was imposed. We agree with the plurality that although the statutory aggravating and mitigating circumstances under the Florida statute are not susceptible to mechanical application, they are by no means so vague and overbroad as to leave the discretion of the sentencing authority essentially unfettered. Under Florida law, the sentencing judge is required to impose the death penalty on all first-degree murderers as to whom the statutory aggravating factors outweigh the mitigating factors. There is good reason to anticipate, then, that as to certain categories of murderers, the penalty will not be imposed freakishly or rarely, but will be imposed with regularity. And consequently, it cannot be said that the death penalty in Florida as to those categories has ceased to be a credible deterrent or measurably to contribute to any other end of punishment in the criminal justice system. Accordingly, as we see it, the Florida statutory scheme for imposing the death penalty does not run afoul of this court's holding in Furman v. Georgia. Also, as in Gregg v. Georgia, we agree with the plurality in rejecting petitioner's argument that under the 8th and 14th Amendments, the death penalty may never be imposed under any circumstances. We accordingly concur in the judgment of affirmance. Mr. Justice Blackmun also concurs in the judgment for reasons stated in dissent in Furman v. Georgia.
I have the judgment to announce in Jurek against Texas, 75-5394. Again, I speak primarily for Mr. Justice Stewart and Mr. Justice Powell, for the three of us have again filed a joint opinion. The issue in this case is whether the imposition of the sentence of death for the crime of murder under the law of Texas violates the 8th and 14th Amendments to the Constitution. The petitioner was charged by indictment with the killing of a 10-year-old girl by choking and strangling her with his hands and by drowning her in the water by throwing her into a river in the course of committing or attempting to commit kidnapping or forcible rape. At the conclusion of the trial, the jury returned a verdict of guilty. Texas law requires that if a defendant has been convicted of a capital offense, the trial court must conduct a separate sentencing proceeding before the same jury that tried the issue of guilt. Any relevant evidence may be introduced at this proceeding, and both prosecution and defense may present argument for or against the sentence of death. The jury is then presented with 2 or sometimes 3 statutory questions, the answers to which determine whether a death sentence will be imposed. In this case, the jury unanimously answered yes to both questions, and the judge, therefore, in accordance with the statute, sentenced the petitioner to death. The Court of Criminal Appeals of Texas affirmed. After this court's decision in Furman against Georgia, the Texas legislature narrowed the scope of its laws relating to capital punishment and adopted a new capital sentencing procedure. The Texas Court of Criminal Appeals has thus far affirmed only 2 judgments imposing death sentences under its new statute. While Texas has not adopted a list of statutory aggravating circumstances, the existence of which can justify the imposition of the death penalty, as have Georgia and Florida, Texas has narrowed the categories of murder for which a death sentence may be imposed. Each of the 5 classes of murders made capital by the Texas statute is encompassed in Georgia and Florida by one or more of their statutory aggravating circumstances. Thus, in essence, the Texas statute requires that the jury find the existence of a statutory aggravating circumstance before the death penalty may be imposed. It therefore requires the sentencing authority to focus on the particularized nature of the crime. But a sentencing system that allowed the jury to consider only aggravating circumstances would almost certainly fall short of providing the individualized sentencing determination that we believe the Constitution requires. A jury must be allowed to consider, on the basis of all relevant evidence, not only why a death sentence should be imposed, but also why it should not be imposed. Thus, a capital sentencing system must allow the sentencing authority to consider mitigating circumstances. The Texas statute, unlike the Georgia and Florida statutes, does not explicitly speak of mitigating circumstances. It directs only that the jury answer certain specific questions. Thus, in our opinion, the constitutionality of the Texas procedures turns on whether those questions allow consideration of particularized mitigating factors. In this case, the Texas Court of Criminal Appeals has interpreted the second statutory question so as to incorporate into it whatever mitigating circumstances the defense may be able to bring to the jury's attention. And in the only other case in which the Texas Court of Criminal Appeals has upheld a death sentence, it also focused on the question whether any mitigating factors were present. As construed, therefore, the Texas statute does provide for consideration of mitigating as well as aggravating circumstances. By narrowing its definition of capital murder, Texas has essentially said that there must be at least one statutory aggravating circumstance in a first-degree murder case before a death sentence may even be considered. By authorizing the defense to bring before the jury at the separate sentencing hearing whatever mitigating circumstances relating to the individual defendant can be adduced, Texas has ensured that the sentencing jury will have adequate guidance to enable it to perform its sentencing function. By providing prompt judicial review of the jury's decision in a court with statewide jurisdiction, Texas has provided a means to promote the even-handed, rational, and consistent imposition of death sentences under law. Accordingly, for reasons more fully stated in the opinion which Mr. Justice Stewart, Mr. Justice Powell, and I have filed with the clerk, the judgment of the Texas Court of Criminal Appeals in this case is affirmed. Mr. Justice Brennan and Mr. Justice Marshall have filed dissenting opinions.
I again concur in the judgment, and the opinion I have filed is joined by the Chief Justice, Mr. Justice Rehnquist. As in the prior cases already announced, we cannot conclude that the 8th and 14th Amendments forbid the death penalty under any and all circumstances. That argument is also made in this case. We also cannot agree with petitioner's other major contention that under the new Texas statute and the state's criminal justice system in general, the criminal jury and other law enforcement officers exercise such a range of discretion that the death penalty will be imposed so seldom and arbitrarily that the new statute suffers from the infirmities which Branch against Texas found in its predecessor. Under the revised law, the substantive crime of murder is defined, and when a murder occurs in one of the 5 circumstances set out in the statute, the death penalty must be imposed if the jury also makes certain additional findings against the defendant. Petitioner claims that the additional questions upon which the death sentence turns are so vague that in essence the jury possesses standardless sentencing power. But we agree with the plurality that the issues posed in the sentencing proceeding have a common sense core of meaning and that criminal juries should be capable of understanding them. The statute does not extend to juries unbridled discretionary power to dispense mercy, and it should not be assumed that juries will disobey or nullify their instructions. We cannot conclude at this juncture that the death penalty under this system will fail to serve any useful penological function and hence fall within the reach of the decision announced by 5 members of this court in Furman v. Georgia and Branch v. Texas. We accordingly concur in the judgment of affirmance. Mr. Justice Blackmun also concurs in the judgment for reasons stated in dissent in the Furman case.
The next case to be announced this morning, the 4th case, is number 75-5491. James Tyrone Woodson and Luby Waxton, petitioners, against the state of North Carolina, respondent. The case which is here on writ of certiorari to the Supreme Court of North Carolina. The question in this case is whether the imposition of a death sentence for the crime of first-degree murder under the law of North Carolina violates the 8th and 14th Amendments of the Constitution. The petitioners were convicted of first-degree murder and mandatorily sentenced to death as the result of their participation in an armed robbery of a convenience food store, in the course of which the cashier was killed. The Supreme Court of North Carolina affirmed the judgments, and we granted certiorari to consider the claim that the imposition of the death sentences in this case amount to cruel and unusual punishment in violation of the Constitution. The petitioner's first and most basic argument is that the imposition of the death penalty under any circumstances at any time is cruel and unusual punishment. We reject this argument for the reasons stated in the opinions that have just been announced. At the time of this court's decision in the Furman case, Furman against Georgia in 1972, North Carolina law provided that in cases of first-degree murder, the jury, in its unbridled discretion, could choose whether the convicted defendant should be sentenced to death or to life imprisonment. After the Furman decision, the Supreme Court of North Carolina held unconstitutional the provision of the death penalty statute that gave the jury that option. But the state Supreme Court held further that this provision was severable, so that the statute survived as a mandatory death penalty law. The North Carolina General Assembly, 2 years later in 1974, followed the court's lead and enacted a new statute that was essentially unchanged from the old one, except that it made the death penalty mandatory. It was under this statute that the petitioners who committed their crime on June 3, 1974, were tried, convicted, and sentenced to death. North Carolina, unlike Florida, Georgia, and Texas, has thus responded to the Furman decision by making death the mandatory sentence for all persons convicted of first-degree murder. In ruling on the constitutionality of the sentences imposed on the petitioners under this North Carolina statute, the court now addresses for the first time the question whether a death sentence returned pursuant to a law imposing a mandatory death penalty for a broad category of homicidal offenses constitutes cruel and unusual punishment within the meaning of the 8th and 14th Amendments. It is settled that the 8th Amendment stands to assure that the state's power to punish is exercised within the limits of civilized standards. Central to the application of the amendment, therefore, is a determination of contemporary standards regarding the infliction of punishment. At the time the Eighth Amendment was adopted in 1791, the states uniformly followed the common law practice of making death the exclusive and mandatory sentence for certain specified offenses. Although the range of capital offenses in the American colonies was quite limited in comparison to the more than 200 offenses then punishable by death in England, the colonies at the time of the Revolution imposed death sentences on all persons convicted of any of a considerable number of crimes, typically including, at a minimum, murder, treason, piracy, arson, rape, robbery, burglary, and sodomy. But almost from the outset, jurors reacted unfavorably to the harshness of mandatory death sentences. The states initially responded to this expression of public dissatisfaction with mandatory statutes by limiting the classes of capital offenses. This reform, however, left unresolved the problem posed by the not infrequent refusal of jurors to convict even murderers rather than to subject them to automatic death sentences. In 1794, Pennsylvania attempted to alleviate the undue severity of the law by confining the mandatory death penalty to murder of the first degree, and within a generation that practice spread to most of the states. But juries continued to find the death penalty inappropriate in a significant number of first-degree murder cases and refused to return guilty verdicts for that crime. The inadequacy of distinguishing between murderers solely on the basis of legislative criteria soon led the states to grant juries sentencing discretion in capital cases. Tennessee in 1838, followed by Alabama in 1841, and Louisiana in 1846, were the first states to abandon mandatory death sentences, even for first-degree murder, in favor of discretionary death penalty statutes. By the turn of this century, 23 states and the federal government had made death sentences discretionary for first-degree murder, and during the next 2 decades, 14 additional states replaced their mandatory death penalty statutes. By 1963, all of the remaining jurisdictions had replaced their automatic death penalty statutes with discretionary jury sentencing. The history of mandatory death penalty statutes in the United States thus reveals that the practice of sentencing to death all persons convicted of a particular offense, even first-degree murder, had been totally rejected years before the Furman case was decided in this court. The two crucial indicators of evolving standards of decency respecting the imposition of punishment in our society, jury determinations and legislative enactments, both therefore point conclusively to the repudiation in our country of mandatory death sentences. Although this court has never ruled on the constitutionality of mandatory death penalty statutes, it has on several occasions, dating back to 1899 in the case of Winston against the United States, it has commented upon our society's aversion to the mandatory sentence of death. 50 years after the Winston case, the court underscored the marked transformation in our attitudes toward mandatory sentences, and I quote from the case of Williams against New York. The belief no longer prevails that every offense in a like legal category calls for an identical punishment without regard to the past life and habits of a particular offender. This whole country has traveled far from the period in which the death sentence was an automatic and commonplace result of convictions. End the quotation. More recently, in the case of McGoutha against California, the court spoke of the American rebellion against the common law rule imposing a mandatory death sentence on all convicted murderers. Close the quotation. So it was that 4 years ago, in the Furman case, the Chief Justice, speaking for the 4 dissenters in that case, was able to say with total accuracy, and I'm quoting, "I had thought that nothing was clearer in history than the American abhorrence of the common law rule imposing a mandatory death sentence on all convicted murderers." We conclude that North Carolina's mandatory death penalty statute for first-degree murder conspicuously departs from contemporary standards respecting the imposition of the punishment of death, and thus cannot be applied consistently with the 8th and 14th Amendments. A separate and perhaps somewhat inconsistent deficiency of North Carolina's mandatory death sentence statute is its failure to provide a constitutionally tolerable response to Furman's rejection of unbridled jury discretion in the imposition of capital sentences. It is argued that North Carolina has remedied the inadequacies of the death penalty statutes held unconstitutional in the Furman case by withdrawing all sentencing discretion from juries in capital cases. But when one considers the long and consistent American experience with the death penalty in first-degree murder cases, it becomes evident that mandatory statutes enacted in response to Furman have simply papered over the problem of unguided and unchecked and unreviewable jury discretion. A third and final constitutional shortcoming of the North Carolina statute is its failure to allow the particularized consideration of relevant aspects of the character and record of each convicted defendant before the imposition upon him of a sentence of death. A process that accords no significance to relevant facets of the character and record of the individual offender or the circumstances of the particular offense, excludes from consideration in fixing the ultimate punishment of death the possibility of compassionate or mitigating factors stemming from the diverse frailties of humankind. It treats all persons convicted of a designated offense not as uniquely individual human beings, but as members of a faceless, undifferentiated mass to be subjected to the blind infliction of the penalty of death. While the prevailing practice of individualizing sentencing determinations generally reflects simply enlightened policy rather than a constitutional imperative, we believe, and when I say we, I mean Mr. Justice Powell, Mr. Justice Stevens, and I believe that in a capital case, the fundamental respect for humanity underlying the Eighth Amendment requires consideration of the character and record of the individual offender and the circumstances of the particular offense as a constitutionally indispensable part of the process of inflicting the death penalty. This conclusion rests squarely on the proposition that the penalty of death is qualitatively different from a sentence of imprisonment, however long. For the reasons I have summarized, we conclude that the death sentences imposed upon the petitioners under North Carolina's mandatory death sentence statute violated the 8th and 14th Amendments and therefore must be set aside. The judgment of the Supreme Court of North Carolina is reversed insofar as it upheld the death sentences imposed upon the petitioners, and the case is remanded for further proceedings not inconsistent with the opinion that Mr. Justice Powell, Mr. Justice Stevens, and I have filed with the clerk today. Mr. Justice Brennan and Mr. Justice Marshall have filed statements concurring in this judgment.
I have filed a dissenting opinion in this case, joined by the Chief Justice and Mr. Justice Rehnquist. Mr. Justice Blackmun is also in dissent, but for reasons that were stated in dissent in Furman against Georgia. Mr. Justice Rehnquist has also filed a separate dissenting opinion in this case. And I should make clear, if I have not before, that the Chief Justice, while joining my several opinions in these cases, adheres to his views expressed in the dissenting opinions which he authored or joined in Furman v. Georgia. As in the other cases, we cannot agree here that the death penalty is invalid under any and all circumstances. Neither can we agree that even though the North Carolina jury is carefully instructed in the elements of felony murder, and even though it is instructed that if the defendant is found guilty of murder, the death penalty must be imposed, the jury will so systematically disobey its instructions that the death penalty will be imposed so seldom and randomly as to be invalid punishment under Furman v. Georgia. In our view, the range of jury discretion under the North Carolina law does not begin to measure up to that which exists under Georgia, Florida, and Texas statutes. And with all due respect, we cannot invalidate the North Carolina statute on Furman v. Georgia grounds, while at the same time sustaining a statute such as the state of Georgia now has. As additional grounds, which were not urged by the parties, for invalidating the North Carolina statute, the plurality would require capital punishment statutes to provide for a separate sentencing proceeding having the characteristics specified in the plurality opinion. This holding, as I indicated in announcing my Gregg concurrence, effectively overrules McGautha v. California, and we would not take that step since it is not required by the 8th and the 14th Amendments. We also cannot agree with the plurality that our history establishes that society has rejected the mandatory death penalty for all first-degree murders as being below contemporary community values. It is true that for several reasons the legislatures of many states for a time discarded statutes mandatorily imposing the death penalty for all first-degree murders in favor of statutes giving the jury unfettered discretion not to impose it. It cannot be concluded, however, that a return to mandatory statutes is therefore unconstitutional, for under the discretionary statutes, the death penalty was imposable on any given first-degree murderer as the jury in its discretion saw fit. Discretionary statutes cannot therefore stand for the proposition that society had or has concluded that the death penalty for first-degree murder was or is inconsistent with contemporary standards of decency. What the plurality does is to strike down the sentencing statute in North Carolina, both because, through claimed jury nullification, there is too much discretion in the sentencing process, and because, due to the mandatory imposition of the death penalty for first-degree murder, once first-degree murder is proved, there is too little discretion in the system. This makes little sense to us, and we would affirm the judgment of the North Carolina Supreme Court.
I have the judgment to announce in Roberts against Louisiana, number 755844. Again, I speak for Mr. Justice Stewart and Mr. Justice Powell, as well as for myself. The question in this case is whether the imposition of the sentence of death for the crime of first-degree murder under the law of Louisiana is constitutional. The petitioner was indicted by a grand jury on a charge that he committed first-degree murder while engaged in an armed robbery. The jury found the petitioner guilty as charged. As required by state law, the trial judge sentenced him to death. The Supreme Court of Louisiana affirmed the judgment. We granted certiorari. The Louisiana legislature in 1973 amended the state statute relating to murder and the death penalty in apparent response to this court's decision in Furman. The 1973 amendments changed the former discretionary statute to a wholly mandatory one, requiring that the death penalty be imposed whenever the jury finds the defendant guilty of the newly defined crime of first-degree murder. Under the new statute, if there was a specific intent to kill or to inflict great bodily harm, and the offender was engaged in an armed robbery, the offense is first-degree murder and the mandatory punishment is death. Any qualification or recommendation which a jury might add to its verdict, such as a recommendation of mercy where the verdict is guilty of first-degree murder, is without any effect. The constitutional vice of mandatory death sentence statutes, lack of focus on the circumstances of the particular offense and the character and propensities of the offender, is not resolved by Louisiana's limitation of first-degree murder to various categories of killings. The diversity of circumstances presented in cases falling within the single category of killings during the commission of a specified felony, as well as the variety of possible offenders involved in such crimes, underscores the rigidity of Louisiana's enactment and its similarity to the North Carolina statute. Louisiana's mandatory death sentence law employs a procedure that was rejected by that state's legislature 130 years ago and that subsequently, at one time or another, has been renounced by legislatures and juries in every jurisdiction in this nation. The Eighth Amendment, which draws much of its meaning from the evolving standards of decency that mark the progress of a maturing society, simply cannot tolerate the reintroduction of a practice so thoroughly discredited. Accordingly, for reasons more fully stated in the opinion which Mr. Justice Stewart, Mr. Justice Powell, and I have filed with the clerk, we conclude that the death sentence imposed on the petitioner in this case under Louisiana's mandatory death sentence statute violates the 8th and 14th Amendments and must be set aside. Mr. Justice Brennan and Mr. Justice Marshall have filed statements concurring in the judgment.
The issues here are very similar to those in Woodson against North Carolina. I have accordingly filed a dissenting opinion, this time joined by the Chief Justice, Mr. Justice Blackmun, and Mr. Justice Rehnquist. The opinion states at some length why we cannot accept petitioner's argument that capital punishment is per se invalid, petitioner's further argument that the Louisiana scheme does not escape the strictures of Furman v. Georgia, and those additional arguments offered by the plurality, which were neither pressed by the parties nor passed upon by the Louisiana Supreme Court, for overruling this conviction. As in the North Carolina case, to reach the result it does, the plurality must conclude that juries will not obey their instructions so often and so systematically that Furman v. Georgia invalidates this scheme. It is true that Louisiana juries are instructed as to lesser included offenses in murder cases, but they may consider these lesser offenses only if the evidence does not support conviction for a capital offense. This is the clear construction of the statute by the Louisiana Supreme Court, and the four of us are quite unwilling to transform the plurality's purely empirical speculation into a constitutional holding. We would affirm the judgment of the Louisiana Supreme Court. Mr. Justice Blackmun also dissents and would affirm the judgment for reasons stated in dissent in Furman v. Georgia.